Hi, everyone. Thank you for joining us today. I'll just give everyone a minute to funnel in. And we'll get started in just a moment. Welcome. Thank you for coming. All right, I will go ahead and get things started. Thank you all for joining today's webinar presentation on who is leading the Wi-Fi 6 patent race. I'm Leah Wilhelm, Director of Demand Generation here at LexisNexis Intellectual Property Solutions. And before we begin, please note that this webinar is being recorded and a link will be sent to you afterward. For questions, please use that Q&A section, and we'll address as many as possible at the end. Now, let's meet our panel for today. First, we have Tim Pohlmann, Director, SEP Analytics at LexisNexis Intellectual Property Solutions, Jack McKinney, who is the Senior Manager of Intellectual Property at HP Legal, David Yurkerwich, Senior Managing Director at Ankura, and Jon Putnam, Partner at Competition Dynamics, Inc. Tim, over to you to get things underway.
Thank you so much, Leah, for the kind introductions. Thank you for the panel of experts to be here. Before I will go to our experts and before we hear more from them about the challenges that we have in SEP licensing when it's about Wi-Fi, let me start with some preview and some snapshots of our currently published Wi-Fi 6 report. Maybe that data can also create some discussion across the panel speakers. To start with, I want to address a challenge that we have in the market when it comes to SEP licensing. As many of you know, there's data in the public about patents that are potentially essential. We call them declaration databases. And while some of these databases, like the one from Etsy, has a lot of patents in there, and we feel that it's over-declared, there's patents in there that may not be essential, we have a much bigger issue when it comes to Wi-Fi, because we have this situation we call under-declaration. Under-declaration basically refers to the fact that companies make a declaration, they declare to own patents, and they declare to license them if they are essential under FRAND, but these are blanket statements. They're not making public which of these patents, or if at all, how many patents and the patent numbers are actually relevant to the standard. Just to give you some numbers, only 8 out of the 49 companies that have ever declared at the IEEE have made so-called specific declarations where they list the patents, right? So we don't see any information on patent numbers. And if we look at those companies that contribute to the IEEE standards development, assuming they also may have patents, right? Only 9% of them have ever made a specific patent declaration. That basically shows that there's really no data on patent declaration for Wi-Fi available. That is why we at LexisNexis IPlytics have thought about this very hard. We have created a database of patents that relate to the different Wi-Fi generation using a supervised learning algorithm. It's called LexisNexis Classification. It's powered by Cypher, a company that actually LexisNexis acquired 2 years ago. And it identifies what we call undeclared patents for the Wi-Fi generation 4, 5, 6, and 7, right? The way this works is it's an algorithm that works with training data. And there is a patent pool in the market. And there's other information in the market of portfolios that have been sold, other information on claim charts of standard, say, essential patents for Wi-Fi that are used as positive examples to then identify all those patents that are not published, that are not publicly available, that are also related to the Wi-Fi standards. We have created that landscape, and I'm saying patent landscape here because we are, of course, fully aware these are not all SEPs, right? We were very inclusive, right? We try to capture every patent that is potentially essential, similar as to a database as Etsy, but not all of these are confirmed essential. Of course, we don't claim chart them all, right? But we believe they are in a snapshot of the landscape of Wi-Fi patent owners, and they allow you to understand who owns what. Why is that even important? I like to show this visual here. And I think one thing to appreciate is that patent pools are not only there to license and aggregate license agreements to have a more efficient licensing process, they're also great because we have data in the market. We have a list of patents that have been approved essential, and we have a price point, right? And I took the price point from the Wi-Fi 6 Sysvel pool here, which is 50 cents per device, right? At least for a smartphone or a computer device, right? The problem, however, we know a price now, but we still don't know, the coverage of that pool. How many of the total stack of, Wi-Fi 6 patents does the pool actually cover? And we do not know which are the companies outside of the pool. And we wonder, are there even companies that we don't even know about that own SEPs for Wi-Fi? The reason may be because they acquired these patents. Patent assertion entities do that. They buy patents from larger portfolios. And those are maybe companies that not everyone has on the radar, right? When we look at the landscape that we created, we do see that the Wi-Fi 6 related patents are still increasing over time. This is the number of families as to the publication date. This is a cumulative count, right? So this is not every year more patents. It's a cumulative stack of patents per year of all those patents that are still active and granted in any jurisdiction of the world. And we also see that, of course, patent filings do not increase anymore for Wi-Fi 4 and 5. We already see Wi-Fi 7 patents in the mix, but we haven't put them in the report here. Another thing worth mentioning is, and I think that has also been discussed in the past, is that wireless technology, which we call the Wi-Fi standard, and cellular technology have parts where they overlap, right? And we have overlap of patents because of that. And we, of course, also have overlap of generation. And we looked at this in the report. What interestingly is, of course, that Wi-Fi 6 has the largest overlap with its predecessor generations, Wi-Fi 5 and Wi-Fi 4, which is probably straightforward. But also interesting is that at least 4% of the patent families we identify relevant to Wi-Fi 6 have also been declared at the ETSI database to be relevant for Wi-Fi 5. And that's something I think experts have confirmed. Some broadly written claims can actually read on 5G and Wi-Fi 6. But in numbers, I think that's an interesting result that we also find that in our database. What we, of course, also do is when we have such data, we look at the different companies' portfolios, right? We look into who owns what, right? And then we rank it, right? We have also a report with the shares, but here in the webinar, I'm only showing you the ranks. And there's different ways to count data. We are fully aware that different ways to refine the data and look at the data creates different ranks. And I think everyone who's using the data should decide what gives you the most accurate picture. And it may be also from case to case that sometimes looking only at US patents makes more sense, or looking at worldwide patents make more sense. Another thing we did in the report is we took the data and we used a statistical valuation metric, which we call the patent asset index, to look at which portfolio looks to be more relevant in terms of forward citations and market coverage, meaning how large is the family worldwide accepted and granted, right? And we're weighting the markets here by GDP. What is interesting comparing these different rankings is that, of course, depending on which data you use, do I use Wi-Fi 4, 5, and 6 patents? Do I only use those patents that are relevant to Wi-Fi 6, excluding everything else? Should I also look at Wi-Fi 6 contributions, which we did in the report? All these kind of things change or may change the ranking of such lists. And interestingly, also the patent asset index changes the situation, where Qualcomm now, for example, is #1 when the patent asset index is applied, or InterDigital jumps from the 15th rank up to the 5th rank when we apply the patent asset index, in other words, some valuation metric to it. Interestingly is also that the Wi-Fi technology in general is a very US-driven technology. We looked here at the shares by ultimate owner's country of region of the headquarter, right? And we see that the largest part is US companies, followed by Chinese companies. Both together make up almost, or in many cases here, more than 2/3 of the companies, right? If you look at those companies that have products in the market that the Wi-Fi Alliance has basically accredited and accepted as compliant to the standards. Those are the implementers. And here we're only counting companies, right? We didn't count products. Unfortunately, we didn't have that data. But still, it's interesting to see that now China is bigger than the US. So there's more users in China than in the US, but still both represent 2/3 of the whole market. So it's a really very heavy US-driven market and Chinese companies-driven market. These were just some snapshots. I just wanted to show you some data to give some background and to get this discussion started with our panel speakers here to give some background. There's a larger report. You can download it here. We will make the slides available. The link is basically if you click on the download button. And now I would like to jump and talk to our great panel speakers that we have here today. And before I do that, I would like to basically present them to you. Just give me a second. With the technology here, I have to close some windows, otherwise I cannot see you. There we go. Let's start with Jon Putnam. Jon Putnam, thank you for being here. Jon is the founder and CEO of Competition Dynamics, an economic consultant firm that has been around for many years now, supporting SEP litigation, SEP licensing efforts of companies. I think it's fair to say Jon has been representing a lot of the SEP owners, even though as an economist, you are neutral to your work. We have David Yurkerwich. David Yurkerwich is a managing director with Ankura. Also, Ankura is an economic consultant firm. Also, David represents both SEP holders and implementers. I think for Wi-Fi, probably more on the implementer side, if that's fair to say. And then we have Jack McKinney, who is an IP manager with HP Inc., which is, of course, selling printers and selling computers that are compliant with some of the Wi-Fi technology that we just discussed today. And maybe to get started, I would love to hear a little bit about the trends and the licensing that has been going on for Wi-Fi. At least what I have seen, we have an increase in litigation and licensing ever since the Wi-Fi 6 technology has been more widely adopted. And I'm asking you, David, because a lot of that is, of course, also behind closed doors, even though without revealing who you support in this. What is your current feeling about Wi-Fi SEP licensing in the market? Can you give us some insights on trends that you are observing?
Thank you, Tim, and thanks for inviting me to participate today. There is definitely a lot of focus on Wi-Fi 6 in both the litigation market and in the licensing market. And in fact, I think to some extent the litigation, the existence of the litigation is causing companies to try to anticipate what their costs might be and how to go about negotiating. It's obviously there's very little information about what rates are actually being paid for Wi-Fi 6. And companies are at all levels of the supply chain are concerned because a chip supplier ultimately might have to indemnify an end device manufacturer for their use of patents, use of Wi-Fi 6 patents. So we're being really contacted by various levels in the supply chain. And we are, of course, seeing this is beyond cell phones and computers. It's all kinds of devices where, for example, point of sale devices are obviously relevant in the Wi-Fi space. And even automotive applications are now becoming interesting. And I'll just say that we've seen cases filed and then deals done. So there's a relationship there. That activity is precipitating licenses being completed. Maybe I'll just stop there for a moment.
Yeah, if I can just ask one follow-up question on this, because we did see already some litigation. Is that if you kind of listen to those negotiations, do you feel there's a similar tension there of things that we've seen in cellular, that it could lead to further litigation just because there's a lot of pressure and the ideas of price and a FRAND rate are yet far, from each other. Is that's what you would expect for the next years to come?
Yeah, I know. I do think there's unfortunately going to be more litigation to try and flush out what the reality is of, what is the value, and how should it be determined. In the cellular world, we've had case law and a bit of a track record establishing parameters and approaches, and here, we don't have that. Now, we of course are working to more or less extrapolate from the cellular world to the Wi-Fi world, thinking about how FRAND should be determined. And this, of course, brings on the table the central point that you already presented, that, well, what's the population of relevant patents that should be considered? And then what should the aggregate royalty burden be for a Wi-Fi device compared to, a mobile phone or a computer itself? So there's lots of difficult questions, both from a patent point of view and then from an economic point of view, that will need to be sorted out. And because there's not a lot of transparency, right, about, what actual rates are being collected, it forces the parties in some cases into a dispute setting where information can be shared.
So to summarize, yet what is missing is actually maybe even a court decision on a FRAND determination of Wi-Fi, comparable license agreements that are somehow accessible, and of course what I presented, the actual patent data that can at least give you some idea of, who owns what and what this total stack of patents could be.
Yeah, and I don't want to get ahead of us, but you can find information in the public domain, even in the U.S. Legal system. There are reports on experts that are filed and sometimes reveal the approach and the methodology. So there's data out there. You just have to dig for it.
Interesting. Maybe I'll ask another question about this later.
Yeah,
David,
yeah.
what's in those reports? Jon, you did a lot of digging, unpacking for many years now, and you did that also across different standards. One big question, of course, always is what is actually FRAND? What is a fair value that the standard brings to the product? Maybe if you could, give us some idea about your approach in this value determination or FRAND determination cases, and your thoughts about, how that may differ from cellular to Wi-Fi, and anything that is maybe also different for Wi-Fi that comes up to your mind.
Yeah, thanks, Tim. We've worked and worked with IPlytics actually for a very long time on measuring the value of cellular standards as well as other standards, and so I have thought about it for a long time. I think one of the things that I've found somewhat disheartening is the lack of commitment to using market data to determine the value of a standard. So if you think of a standard as being a collection of individual inputs that itself creates value for a standard implementer, people have tried to guess what that value is. The Ericsson commitment to or whatever, the single digit commitment in cellular and that sort of thing. People haven't worked nearly as hard to measure it. And so if you think of a standard as being a productivity improvement over a prior generation, then the question is, what are people willing to pay for that productivity improvement? So the question we've asked, for example, is how much more are people willing to pay for a 5G handset than for a 4G handset that is otherwise identical? And of course, the otherwise identical is doing a lot of work there. You've got to figure that out statistically because you don't actually have typically identical handsets. And the same thing is true for Wi-Fi, with there being two difficulties that are not present in cellular. One of them is that the most widely used databases don't actually track the introduction of Wi-Fi 6 compared to Wi-Fi 5. So you have to go out and scrape the web to figure out which products are using Wi-Fi 6. And that's a tedious process. and subject to, error and sampling problems and that sort of thing. And then, of course, as you pointed out, people don't know which patents are potentially essential to Wi-Fi 6. And that's why I commend IPlytics for, trying to use a large sample machine learning model to figure this out. In a different context, a different standard, digital subscriber lines, we did face the same difficulty where state patents weren't declared. But we actually enlisted expert help combined with oversampling methods. So you can figure out, you can take a sample of technologies where you see patents that mention DSL, for example, or ADSL or VDSL, and you can submit a sample of those to experts to determine essentiality rates and estimate the approximate number of essential patents. It's not nearly as large as it is in the case of Wi-Fi 6, but it can be done. And similarly, you can take other approaches besides the ones that we've taken in cellular, where we look at changes in price. In the case of DSL, you look at what is the cost savings from being able to use digital subscriber line technology to run over a telephone wire instead of having to rewire the last 300 feet from the curb to a house. That's really the productivity improvement that's afforded by DSL and its later variants. So all of this is to say is that there are ways around these problems, but they are statistically and economically not simple, and it's difficult to get people to agree on a methodology because you're usually developing these things in a dispute-related context where people have every incentive not to agree on the legitimacy of the method.
Great. Thank you, Jon, for that input. And yeah, I agree. I think technically there are some advancements that we can see from Wi-Fi 5 to 6, like more throughput, better latency, more devices that can access a router. But the big question, of course, is always, with these improvements, are the products in the market actually making use of those improvements to that extent what it is improving? And now going to you, Jack, you've been for quite some while with HP now. You've seen and probably also experienced more than I did the increasing litigation in the space. HP has been, at least some of the public sources say that, listed as a defendant in some of the litigation cases. And litigation is typically the tip of the iceberg, right? This is a situation where the negotiation somehow fails, right? Could you elaborate on why that sometimes is this the case and what the current challenges are in the Wi-Fi context of SEP licensing? What are your thoughts? What are your feelings? What's going on right now?
Well, thanks, Tim. First of all, I can't speak about any pending litigation or anything like that, so I'm not going to kind of go there. So what I want to do is try and speak about address your question, this topic, a little more generally from an implementer's perspective. And the points I'm going to make, they're not necessarily unique to Wi-Fi. Wi-Fi does have some uniqueness to it, but in general, when we're talking about negotiations, SEP licensing negotiations, anything I say here typically applies. Now, the first thing I want to say is I don't think it's quite fair to say that litigation always results from a breakdown in negotiations. It's a breakdown. Breakdown might be the wrong word. Sometimes you'll see that there's some reasons, some problems in the negotiations, the inability to close gaps, that when litigation becomes the route to more efficiently close a gap, unfortunately, then that's oftentimes when it happens. So these gaps. So say from an implementer's perspective, and I want to maybe just raise a point about the term implementer. When you're talking about Wi-Fi and other things, an implementer could be the chipset provider, right? The component, and the PC manufacturer, PC supplier could be more of an integrator. So this differentiation kind of can expound on these gaps a bit. So the gaps I'm talking about, the first one is the knowledge gap. And that's in line with what you've been, you and the others have been talking about. It's not knowing what the total impact is. What's the final price tag for paying for Wi-Fi or for paying for HEVC or paying? What is that? What is that total number? I mean, that's what I need to be able to share with the decision makers at HP. They want to know what's the total price and will this be finally settled once and for all? The other knowledge gap, and this is even for the integrator, is essentiality. Are these patents really essential? We don't. I mean, the integrator does not build the technology. They take a chipset from a supplier, integrate it onto with the rest of the components, and produce the PC. So sometimes the ability to determine essentiality, it can be quite hard and take time, especially when this is a new when it's a new SEP licensing area to become familiar with. Lastly, I guess then once you have the knowledge gap, then you have a gap on terms and price. When the implementer or the integrator doesn't have the knowledge, doesn't know what the value of the standard is, what the total price tag could be, it's really difficult to know if an offer from a SEP holder is in fact FRAND. There's nothing to gauge it against. Other times, the implementer may already have licenses, and they use those licenses to determine what they believe to be a FRAND rate. And unfortunately, the SEP holder believes their patents are more valuable and has a much higher price. And those differences can be orders of magnitude in price. So and unfortunately, that's litigation in some cases is the way to solve and close those gaps. In litigation, more information is shared. You're able to see, parties are able to see agreements, understand what their competitors impact on competitors. So anyway, I think I can stop there, Tim.
Oh, it's interesting to hear, Tech, that litigation, which is not often, even for you as a defendant, is something you can also have, positive, effects from, right? Because usually you think like anyone who is litigated, right, as a defendant. But in our world of SEPs and FRAND determination, of course, a litigation can bring clarity, right? Especially with the UK courts, I guess.
Yeah, it can bring clarity. I don't want to say it's positive. It's not the goal. And ideally, there would be no litigation, and you can get there. I just want to make that clear. But unfortunately, in certain cases, yes, it's what comes out of the litigation is sometimes the parties are closer, and oftentimes neither of them are happy. So,
which I keep saying, if everyone is equally unhappy, we have a good solution, maybe.
Yeah, maybe.
But again, I think some of the FRAND cases allow experts like Jon and David to unpack and understand if, that ruling or, even some comparable licenses that were used in court can be used for the next, negotiation, to have some reference points, to have some price points. And I think that is similar to when I discuss the data, right? People ask me, oh, are you sure this is the actual share of this particular company owning Wi-Fi 6 patents? And I keep saying, similar like FRAND is a rate, also the size of their portfolio and the value of their portfolio is a range, right? And these are the things that we have to work with in our industry, that things are a range and that we have to come to some agreement where we find like some middle ground. Let's talk about patent pools, right? Patent pools, I think, I'm an economist. When I started to learn IP, patent pools were considered as, the one-stop shop. Of course, we can all see the efficiency gains. We save a lot of transaction costs. But of course, pools also come with challenges. To start with, many pools cover patents from, their members, but they don't own them. That means they cannot enforce them, right? So they are somewhere there in the market to be the middleman, but the pool program is not enforceable, right? Only the members can go out separately to enforce. And then, of course, a good question is, who has set the rate for the pool, right? Were these the members, and is that rate a friend rate, right? Jon, what do you think of patent pools? What is their function in the market? Do you believe they facilitate the licensing? Any thoughts?
Well, it's hard to argue against patent pools. It's like being against motherhood and apple pie, because they allow people to negotiate with fewer entities, and since you're dealing with complementary inputs, to obtain a lower rate, that presumably, than if you were negotiating separate rates for all the constituent entities. That said, I think two things are true. One question to ask is, why isn't the Standard Development Organization itself the patent pool? One of the odd things about the way SEPs are licensed is that if you say, think of it this way: if when you buy a car, you contract with the car manufacturer, you don't contract with the manufacturer of the leather seats and the transmission and the tires and that sort of thing. All of those negotiations are entered into by the car manufacturer, and you decide to buy a car or not. In the Standard Development Organization, being a nonprofit entity and sort of like outside the market, takes inputs that don't belong to it and assembles them into a final good called a standard, and then allows customers to use that final good at a price of zero, and asks the customers to contract with the people that it took the inputs from. So that would be like me going out and getting a Chevrolet for free and then having to bargain with the manufacturer of the exhaust pipe for the rights to the exhaust pipe, and pay separately for that. So that's actually crazy. So a patent pool removes some of that craziness, but doesn't remove all of it. The second problem with it is that firms have different incentives to join patent pools, and patent pools are not necessarily terribly good at allocating the payments that they receive. So you would expect that if you had an unusually high quality portfolio, but you were only going to be compensated at an average rate from a patent pool, your incentive would be to go it alone and not join the patent pool. Whereas if you had a lower quality portfolio and you expected to be compensated at an average rate, then you'd want to join the pool. You save on enforcement costs. So you get a selection bias in pool members, where, I mean, and this varies from pool to pool and company to company, so I don't want to name names, but on average, you might expect that the people with higher quality portfolios don't join pools, and the people with lower quality and smaller portfolios do join pools. So the rates you observe in a pool tend to be biased indicators of the value of the entire technology. So while it's convenient for people to shop from a pool, it's not necessarily an accurate measure of the total value of the standard. And so you're always kind of on the one hand praising the pool for existing, and also then denigrating it as a source of information, because you can't necessarily rely on the prices that are being charged for an accurate picture of what any individual firm should charge on its own.
Right. No, that is, I think, well understood. I think, I mean, the one thing I would say why standards organizations are not pools is because the members of standards organizations are also consuming the good, right? And some are, some not. There's different business models. It's probably difficult to get everyone together on both developing the standard and licensing. That would be my 2 cents to it. But it's an interesting thought, right? David, you have a comment?
I was just going to say, I've been doing some work in the pool area and brainstorming about how to improve the organization of pools. And responding to John's point, the pool itself could and do, right? They actually review the essentiality. The patents that are contributed have to be reviewed, and they could be scored in terms of their relative contribution. So, and as long as it's transparent and there's a process, then the members could feel like, well, I'm being treated, appropriately. Mine might be a little less or a little more, or a lot less or a lot more. But so there can be a process that deals with that problem.
Which sounds very much like the internal pool process where everyone submits patents and they get scored because of the revenue distribution within the pool, right? And if we have some of the pool programs that are as big and coverage as Avanci, we could even think that their distribution has a lot to do maybe with some of the value distribution across cellular, for at least for the case of vehicles.
Of course, that's not transparent though.
And that is not transparent. That's the big issue, I guess. But to you, Jack, as an implementer, how do you view pools? I think, of course, economically speaking, you get access to patents from a couple of companies compared to just one. But of course, I know that also in the past there were challenges with pools. What are your thoughts on patent pooling?
Patent pools, in theory, are great. It's just amazing. A place where you could go get. Just look back to the H.264 pool from MPEG LA. Absent a few others on the outside, covered most, if not all, of H.264 patents. You could go get one license. You felt quite comfortable, and we're done. So that was great. It was the one-stop shop type approach. That's never 100%, but that's where I saw a lot of value. You can see something similar with via licensing's AAC pool for audio codecs. It seems to be a one-stop shop there. But if this goal of efficiency from the pool for it to be realized, and we're seeing in cases, as time goes on, it's not being realized, but the pool itself, it needs to be able to pull in the majority of the licensors. It needs to have traction, and it really needs to offer think about the price and the value of the technology. So when I look at Wi-Fi 6, this is just an example, and Tim, you showed the 50-cent rate from Sysful. If you extrapolate that out across all the license owners, patent holders you can get to, the price quickly exceeds the MSRP of the chipset. So you put yourself in my shoes trying to explain that to an executive as to why is the patent licensing cost more than the component cost. You can imagine that there's questions of reasonableness. So I think sometimes the problems with the pools and the pricing is just the motivation. So if the motivation of the pool and the licensors is simply to maximize revenue, it's going to lead to these types of problems. You need to consider adoption and consider just the realities of the marketplace of the implementer and the integrator.
Tim, can I just respond to that for 1 second?
Yeah, please.
Oh, yeah. Go ahead.
So
please.
I think that Jack's point illustrates a much larger problem that's, and I realize this is a webinar about Wi-Fi 6, but Wi-Fi 6 is subject to a lot of the problems of SEP licensing generally. Jack mentioned the problem of, well, a patent pool needs to represent the majority of licensors. Well, how do you get there? You have to get the first one, then the second one, then the third one. And there's this question of, sequencing, and then what happens as you've got more people, you set terms, you start collecting royalties, then what happens if somebody else joins? You dilute the pool. And The same thing is true on the side of, so licensors have this coordination problem because they're not all in the pool automatically and they join in sequence. The same thing is true for licensees. There's lots of people who would like to sign a license, but they'd like to sign a license if all of their competitors sign licenses. So they're all experiencing a cost increase at the same time, because who wants to be the idiot who goes first and signs a license when everybody else is getting it for free? So what you've really got is a economic good, which is a standard that is not being treated like a single economic good that is being used and sold as a single economic good. You've got the people who supply the inputs to that good and the people who are using the inputs to that good. And they have this massive coordination problem among themselves that is never going to go away until you treat this as a single good for which you pay in advance like everybody else pays for any other good in advance. I don't get a car unless I go into the dealer and I say, here's $40,000, give me the car, you know? So it's,
Right.
this is a, there's no, so for example, there's no reason why the patent licensing cost shouldn't be greater than the chipset cost. That's intangible property, may be very well more valuable than the hardware, in the same way that when you take a airplane flight, there's no reason why the cost of the fuel shouldn't be greater than the cost of the rental on the airplane. You know, fuel could be the most important input. There's no reason why that shouldn't be true. But it is very difficult to sell this to your management if the fee you're being asked to pay is a fee that no one else is paying. That's a crazy question, you know, because like, you know, the chipset costs $3, the royalty fee is $5, and everybody else is paying $3, and you want me to pay $8. That's a hard no. Whereas if everybody is paying $8 because they have to pay $5 for their licensing fee, because you've coordinated, and so everybody's paying for the same amount for the same thing, then you've got much less cost pressure, because then the price of the device, the hardware plus the IP, actually reflects its true economic cost, and everybody has to pay it.
Yeah, and Tim, if I could just continue on with Jack and Jon, just to build a bit. So Jon's point about where's the value gained, it may not be, you know, at the chip level, it's gained in the end product. And so there you have the problem of who should pay at each level of the supply chain. So that's part of the problem. Like, where is the value realized? You know, where's the money? And if it's not with Jack, it's with Jack's customer, perhaps. And this can be analyzed. The other thing, though, Jon, we've been thinking about this problem of pools evolving, and the licensors and the participants, the licensors and licensees. This could be cared for, right? You just have a pool that adjusts with additions on both sides of the equation. And then picking up on what Jack said, a successful pool can be one where you have people that are both patent holders and implementers. So they agree, you know, that they owe money at the same rate that they're collecting it. It's all about transparency. So we've been playing with, we've been working on modeling kind of the perfect pool, if you will. Kind of fun.
That sounds good.
Very good.
I guess, I mean, the complexity probably is also we don't have two groups, one implementing and one owning the patents, right? They, as we say, some are both. And obviously, you know, that is why there is, you know, this is a difficult game. And I think from Jack's perspective, he needs to ensure the level playing field, all his competitors pay the same, right? Because then you compete on the product market and consumers gonna pay that extra dollars for SEPs, right? I mean, that's probably the reality. But if there's competition that somehow pays less in certain markets and, you know, produces there and then ships over, we have different jurisdictions, different enforcement in these jurisdictions. That all creates, of course, the complexity that we're in, that, you know, you may lose time or you may use your competitive edge in your particular one market because your competitor comes from a different market with unlicensed products. And then they're maybe like 2 years ahead with cheaper products. So I think that is timing, coordination, as Jon calls it, and then, you know, modeling the perfect pool. I would love to see that, David, but I think it's also one of the issues is the dynamics, right? That one is first, chicken and egg, the other one is second. There's time lag between. Some is in litigation, the other one isn't. One's producing in China, the other one in the US. And then you have differences, right? And one owns a portfolio themselves and can cross-license, the other can't. How can you weigh that in, right? In terms of pools as a reference point, I think it's difficult. Jon said that earlier. Is it really a reference point? You, Jack, say, you know, if I extrapolate it, I have issues. David, any thoughts on patent pool rates as a reference point? Is that a good comparable, or is it always difficult?
Well, I think the published rates are just that. They're published rates. They're not necessarily the actual rates. And, you know, one of the problems is that there are often lump sum deals. So there's paid up licenses at pools. So, and then pools have running royalty licenses as well. And the lump sum deals need to be unpacked for comparison to the reference rates or the program rates. And of course, unpacking is challenging because the lump sums can include payments for the past and payments for the future. And how do you value those payments for the past and the future? And you know, what markets were involved, what countries were involved, what was the patent coverage in those countries? So it can get quite complex, as we've seen in the cellular world. And then here, of course, we have the further problem of the 50-cent rate. What does it apply to all devices, or how will it vary across the spectrum of products? And if you're a supplier of chips, that rate seems quite large to you.
Right.
So it doesn't work.
Right. Yeah, I think Sysvel says what this relates to, but it is only one product category, right? There's no other product categories listed, I guess, as far as I see.
Right.
Right.
Right. I would say it only covers Wi-Fi 6, not Wi-Fi 5, not Wi-Fi 4. So some of the problems there, you can think from an implementer, they want, when they take a license, they want to be licensed. My Wi-Fi 6 chipset implements Wi-Fi 5 and Wi-Fi 4. They're backward compatible. They have to be. So right. That's another type of issue that can cause pools when they're to be less efficient. Let's see, and not meet their intended purpose.
That makes sense. Let me read one of the attendees' question here, maybe because it kind of builds off of some of the discussion here. Someone is asking, building off David's transparency for pricing across supply chain, how can SEP owners and licensees address transparency issues without a public SEP database for Wi-Fi 6? Should pool administrators step up to provide more guidance on such royalty transparency importation? And then that same user earlier asked, how do you see such AI methods? So I think that's the methods that I presented. Could these give more transparency? What's your opinion on it?
Well, I would say IPlytics is providing more transparency, and Sysvel is providing transparency on which patents are in their pool. So, we have the ability to compare the two, which is fantastic. But we do see that what Sysvel has is not all of what's in IPlytics as blanket declarations. So, and then we see Huawei also asking for 50 cents, the same rate. And then we wonder, okay, well, but does that cover all, their blanket, or, how does that work, right? So, IPlytics is helping us with transparency for sure.
Yes, I agree.
Thank you. That's great to hear. I have to say, though, that, of course, one thing that we do not recommend our users is putting the Sysvel, claim charted third-party approved SEPs into the numerator and then our data, which includes both, in the denominator. That obviously, is inflating the world. I think if you're using our data, you have to stay in our data, right, landscape, and you can aggregate and you can look at the patent, the pool members who are members of a sister pool with our method of how much is in there. And then, some of the portfolios are larger than the one that Sysfair puts online. And of course, the one that Sysfair puts online is an example of claim charter patents, as you know. You can choose and pick as an owner if you want to submit more because it costs you money to get them checked, right? And there's also some companies to do more and some less. It doesn't always exactly present or represent the whole essentiality world. Just some limitations I think I'm always should mention, because I don't want to say that we have the holy grail to solve everything, but as I'm glad we contribute to some part of the transparency, even though it's not yet, we're not yet at the end of it. Any opinions from you, Jon? What do you think of? Can this be solved with more data, and if so, why? As an economist.
Well, if you forgive me a short story, it took me 13 years to finish my dissertation, and one of the reasons why I finally realized was that I was a victim of data lust. And I thought that if you just assembled more data, you could solve all the world's problems. And I only finished my dissertation when I realized that I needed to cut out 95% of the data that I had collected and focus on actually analyzing the 5% that I could make sense of, which, as it turned out, allowed me to measure the value of all the patents in the world. So by giving up data lust and thinking about modeling, I actually made a lot more progress than by simply trying to get more data. That said, in general, an economist would say more data is better. But I think that it's better. That story illustrates another point, which is that you have to know how to analyze the data that you have. And my experience has been that people don't actually know how to analyze data or agree on the methodology. So, for example, when you're unpacking licenses, people come to vastly different interpretations of individual licenses. While the call for transparency, I think, is important and attractive, it doesn't necessarily guarantee that people are going to come to agreement on the things that they see once the world becomes transparent. So I'll give you an example. I worked on the Federal Trade Commission case against Qualcomm. And in that case, the parties subpoenaed every single standard essential patent license in the industry for 2G, 3G, and 4G. They got all of them. But the Federal Trade Commission didn't make use of all of them. They wanted to show that Qualcomm was bad, and they used a handful of licenses, like 5, to try to make the point that none of which were Qualcomm licenses, to say Qualcomm was charging too much money. We, on the other hand, developed an econometric model of all the licenses in the industry: cross licenses, one-way licenses, fixed payment licenses, running royalty licenses, how many patents were licensed by each party, what were their expected sales, and so forth, and on and on and on. It was a hugely expensive undertaking to try to model this. And what we were able to show was that the simple-minded methods adopted by the Federal Trade Commission could be rejected when you actually asked the right question. The data rejected the simple approach that the Federal Trade Commission took towards analyzing its handful of licenses. And it's that simple approach that has marked the approach to analyzing licenses by other regulators and courts around the world. So if you were to mandate that licenses be available, for example, in the interest of transparency, that doesn't necessarily mean that you're going to get better visibility into the interpretation of the individual contracts, because people don't agree on the methods for analyzing those things. And we showed that those disagreements are fundamental, and if you ignore them, you will misinterpret the agreements that you're looking at.
But with experts like David and you, Jon, I feel like we have people that can maybe make use of that, data if it will be there. But again, I understand your point. If it's just fractions of data, it's also hard to say, what it represents and how representative it is if it's not all. And I think that's probably unrealistic to ask or to have all licenses out there. And any thoughts on transparency for you, Jack? Also, license agreement, but also patent data.
Yeah, I'd say, yeah, license agreements for sure. That's the biggest, some of that's the biggest piece, right? We all already talked about, our decision makers. They want to make sure our competitors, they don't necessarily want a better deal than the competitors. That's nice, but that's not the goal. The goal is to make sure we're not disadvantaged. We want to be able to compete on quality, not based on some unfair, lack of a better word, tax on some components. So that's helpful. More data on patents, being able to see from the outset. You can imagine there's support for some form of transparency. I think is going to improve transparency is going to have to come, whether that be from regulation or from government regulation or self-regulation. And I really, it would be interesting to see a standards body also act as the pool administrator. I'm not holding out high hopes, but that would be something else.
Tim,
So
if I could just comment on John's point about the unpackings.
Yeah.
I think the U.S. I didn't mean to. Did I interrupt you, Jack? I'm sorry.
No,
Okay.
you're quite good.
Okay.
Go for it.
I just think the UK courts have caused all of us to understand the unpacking process more and more, because we have hundreds of pages of explanation of how the experts go about doing things. So that's really good news. Maybe the bad news is some of their decisions take leaps and try and potentially go beyond the unpackings and bring kind of new theory into play. So there's some problems there. And Tim, just to follow up on what I referred to before, another LexisNexis entity, Lex Machina, as many of us know, gives you access to court filings. And in the US, we have these Daubert challenges to experts, and sometimes they're not redacted, and you'll get the testimony essentially and the theory of how Wi-Fi rates are being presented to juries in the United States. Now, then the case is settled, so you don't really know what the deal was, but you have some visibility on the evidence that's being presented.
Great. I think that's all great input, guys. What I always do at the end of the session, and we are already at the end, I could talk about this forever. I give all of you guys the chance to give your, let's say 30-second summary of what you think about how Wi-Fi 6 evolves, and what the challenges are ahead, and how you see the future. Jon, you want to get started with your final statement?
Well, I
put you on the spot.
Yes, I mean, in other words, I think my final statement is not limited to Wi-Fi 6, although it does apply to Wi-Fi 6. Wi-Fi 6 is a valuable technology, and it's manifested in higher prices that people are willing to pay for devices that practice Wi-Fi 6 over Wi-Fi 5. So the question is, can you measure that increment to value, and then how do you distribute that among the patent owners as well as the implementers themselves? The problem, this is my closing point, is that I don't think you're going to be able to solve that problem and avoid the disputes that we see unless you have symmetric commitments to pay. So right now, commitments are asymmetric. The patent owners have to commit to price fairly, but the implementers don't have to commit to pay fairly. And that's just in terms of, historical contractual practice, that's an odd asymmetry. I think that if and when that's rectified, the system will become more balanced, and you'll see better implementations on both sides, better pricing on both sides.
Great. Thank you, Jon. David?
Well, I think it's interesting days ahead as we try and discover what a FRAND rate is for Wi-Fi 6. And I think we will build off of what we've learned in the cellular world, and then try and reconcile it, if you will, between the differences between cellular rates and what those standards provide compared to what Wi-Fi 6, and then of course looking at Wi-Fi 6 compared to Wi-Fi 5. So, and then there are decisions out there with Wi-Fi rates in them. So, you can extrapolate off of existing data. So, but all of that takes effort, and how much of that is justified in a negotiation before litigation, who knows, right?
So you're an optimist, David. Thank you. Jack,
Yeah.
your final words.
Well, Tim, I just want to thank you for inviting me to participate. But as final words, my hope is more of a hope is that transparency continues to improve, find ways to share information, so that we have on the one side we have the SEP holders who have committed to offer FRAND licensing, but without transparency, can there ever be FRAND licensing? Could there ever be true FRAND rates? So maybe a path forward for us all is to work on even more on transparency, work on taking down the roadblocks that prevent and sometimes the ruses that both sides, implementers and SEP holders, use to say that, well, we can't be transparent because I have confidentiality obligations. I think that's the biggest problem, the biggest roadblock to getting to comfort and licenses.
Great. Thank you so much, Jack. Leah, I think we heard a great discussion today. We do have challenges. Wi-Fi 6 licensing is not at the end. It's probably a lot of things ahead of us, but I heard some very creative ideas, especially from our economic experts here, but I think that's your job, guys. I heard from all of you that more data also on patents can solve some of the transparency, and I'm happy that LexisNexis IPlytics can do that, or also even LexisNexis Machina with the court data. So I think we discussed a lot. I think to you, Leah, I think we are at a point where we have to close this webinar.
Yeah, thank you. If we missed your questions today, we'll follow up via email along with the recording. And once this webinar commences, you will be prompted to fill out a brief survey. So if you want to continue the conversation with us, please respond yes to that last question. Thank you for attending, and have a great rest of your day. Thank you.
Thanks, Tim.
Thank you.
Bye.
Take care.
Bye.
Bye-bye.
Thank you.